In the previous lesson, we talked about the first instance in which we can make a claim for voluntary manslaughter, which essentially reduces liability through the operation of a partial defense. In this lesson, we're going to talk about the next major method by which you can utilize this reduction in liability, essentially, moving away from looking at diminished responsibility to this idea known as loss of control. So, again, this is a partial defense for the crime of murder, which then reduces liability to manslaughter. Again, the justification for this owes really and mainly to the sentencing requirement that exists for judges when it comes to successful convictions of murder. So in a successful murder conviction, there is a statutory requirement which essentially is imposed on judges that require a minimum of a life sentence. Whereas when we talk about manslaughter cases, there is a requirement that life sentences are a maximum. And so, as a result of which, the satisfaction of a partial defence, and therefore the reduction from murder to voluntary manslaughter at least, can essentially give a judge a bit more discretion in terms of sentencing and what to do about sentencing. So loss of control is one of the ways in which you can prove this. It is a it is a defense, should I say, a partial defense, which replaces the old defense, which used to be called provocation. Now, it's relatively similar in terms of the general aim and the gist of what this defense is trying to get at, in the same case as that of provocation. And it is also outlined in statute, specifically Section 54 of the Coroners and Justice Act from 2009. And Section 54 of the Coroners and Justice Act says the following. They say that where a person, D, i.e. where a defendant, kills or is party to the killing of another, a victim, the defendant is not to be convicted of murder if the defendant's acts or omissions in doing or being party to the killing results from the defendant's loss of self-control. And B, the loss of self-control had a, quote, qualifying trigger, and C, a person's a person of defendant's sex and age with a normal degree of tolerance and self-restraint, and in the normal circumstances of the defendant, might have reacted in a same or similar way. You can see here the similarities between the loss of control defense and the diminished responsibility defense, because what loss of control is getting at is somewhat similar to that of diminished responsibility. With diminished responsibility, there is a requirement of a recognized medical condition, which essentially impairs the ability of the defendant to act logically and rationally and to have self-control. When we talk about the loss of control defense, there is an act or omission is done as the result of a loss of self-control. That is the first requirement. The second requirement is that this loss of self-control has a, quote, qualifying trigger. We'll get to what this qualifying trigger means in a minute. But ultimately, essentially a justification which is recognized in law as being valid for this particular partial defense. And then finally, you then have to judge the actions of the defendant on the basis of their sex and age. So somebody who is roughly the same age as the defendant and of the same sex as the defendant, given a normal degree of tolerance and self-restraint, a general reasonable amount of tolerance and self-restraint, in the same circumstances of the defendant, would they have reacted in the same or in a similar way to the defendant? So essentially, this is a requirement for an ordinary person test, if you will, or a person, or a standard of a person of a similar characteristic as the defendant in similar circumstances. Would they have acted in a similar way, or even in the same way? Let's begin with the first of these issues: the loss of self-control. The components are the loss of self-control itself, the fact that this loss was caused by a qualifying trigger, and then whether or not this the qualifying trigger and the loss of self-control fits into what we would reasonably expect of a person of a similar characteristic acting in those similar circumstances. It must be shown that that the loss of control and the qualifying trigger are both present, and then it is up to the jury to make a determination about whether or not it was the qualifying trigger which resulted in the loss of control. So you must show loss of control. You must show where this loss of control comes from as a defense, so i.e. the qualifying trigger, and then the jury has to make a decision. Did this qualifying trigger reasonably cause the loss of control? Was there a reasonable amount of causation in this particular regard? Section 55 of the Act says the following. I'm not going to read all of it because I'm only focusing on the specific elements relating to the qualifying trigger. So, Section 55, subsection 2 says a loss of self-control had a qualifying trigger if subsection 3, 4, or 5 applies. So, essentially, if you are the prosecution and you have been given a defendant who is charged with murder, and the defense is arguing for voluntary manslaughter by way of loss of self-control, of loss of control, they will present a trigger. They will have to present a qualifying trigger which causes this the loss of self-control. Now, in order for this qualifying trigger to be justified, to be justified by law, it has to fall within subsection 3, 4, or 5 of Section 55 of the Coroners and Justice Act. Subsection 3 says that this subsection applies if the defendant's loss of self-control was attributable to the defendant's fear of serious violence from the victim against the defendant or another identified person. So the qualifying trigger for loss of self-control in this regard would be fear of serious violence. So if the defendant fears the victim is going to be seriously violent and could potentially kill or cause serious grievous bodily harm to the defendant or another identified person, then this is the qualifying trigger that represents the loss of control in terms of the killing of the victim. Subsection 4 says that this subsection applies if the defendant's loss of control was attributable to a thing or things done or said which constituted circumstances of an extremely grave character, and B, caused the defendant to have a justifiable sense of being seriously wronged. Very, very vague. Subsection 3 is quite nice because it gives us what is reasonably understood to be quite an easy to understand qualifying trigger. The idea of a serious fear of violence coming from the victim. But subsection 4 talks about things said or done which are of an extremely grave character and caused a justifiable sense of the defendant being seriously wronged. Now, subsection 5, which is the final application, simply takes a combination of the two. So, in their most unique form, you have subsection 3 and subsection 4, which are the most important. Let's see how some of this is actually applied in the case law. And we can begin with the case of Crown versus Jewell from 2014. In this case, the defendant had driven to the house of the victim, and the reason for this, they drove with a particular reason, was said to be to pick them up for work. Okay. Now, a number of things takes place, which ends up with the defendant shooting him with a shotgun at point blank range. So, of course, not the most successful of pickups ever. The defendant argued that he had the partial defense of loss of control. So, given this fact, you have to then think, okay, well, what's the qualifying trigger? Did the qualifying trigger lead to the loss of self-control? And would, given all the circumstances, given the qualifying trigger, given the loss of control, is this what a reasonable person of a similar characteristic to the defendant would have acted in these circumstances? What they said, in the Court of Appeal said, was that the idea of loss of control relates to, quote, the loss of the ability to act in accordance with considered judgment or a loss of normal powers of reasoning. Okay? So, in a similar way to the previous defense of diminished responsibility, we're talking about an impairment of the normal powers of reasoning, if we're going to use the language of this particular case. But rather than that being caused by some medical condition, a recognized medical condition in the case of diminished responsibility, In the case of loss of control, it is the loss of the normal powers of reasoning caused by a qualifying trigger. And the qualifying trigger is either the fear of a particular of violence against you or against another individual, another third party, or the idea of the acting with an extremely grave character. Okay. Another case here is the case of Crown versus Clinton from 2012. In this case, we have the defendant who was married to the victim, where he found out that the victim has been having an affair. Okay, so the victim isn't a particularly pleasant individual. Now, upon hearing this news, the defendant suggested that he was going to kill himself. To which the victim responded with the following quotation that he did not, quote, have the balls. So not only is the victim having an affair, but then is acting and responding in a particularly unpleasant way to a potential violent response by the defendant, suggesting that he doesn't have the courage, essentially, to kill himself. In response, the defendant doesn't kill himself; he kills his wife by beating her over the head with a baton. Again, nothing about this particular case is pleasant. Now, at trial level, the judge found that the evidence of infidelity was not admissible under the provisions of the Coroners of Justice Act and Justice Act Section 55(6)(c). So, the question of trying to utilize loss of control, the judge found that the evidence of infidelity could not be used, essentially. It was not admissible for that particular question, suggesting that infidelity can't be a qualifying trigger for this for the use of loss of control. Now, what the Court of Appeal did was correct this and order a new trial. They argued that sexual infidelity could be admissible in establishing the context for a qualifying trigger. But they also made it clear that this does not mean that sexual infidelity was in and of itself a qualifying trigger for the loss of control. See, what the trial judge had done is essentially come to the conclusion that infidelity was not a qualifying trigger for loss of control, which is true, and which the Court of Appeal agreed with. But in doing so, in coming to that conclusion, they then said that any evidence whatsoever relating to this sexual infidelity was inadmissible, and so therefore could not be heard by the jury. But what the Court of Appeal said was, while the trial judge is correct that in and of itself sexual infidelity cannot be a qualifying trigger, cannot be the qualifying trigger, it could still be admissible for establishing the context for what could be a qualifying trigger. So it might not be a qualifying trigger in and of itself, but it might contribute to the establishment of a qualifying trigger. This is quite interesting, because what this does is, first of all, it tells us that sexual infidelity is not a qualifying trigger. So if your significant other has an affair or cheats on you, okay, you can't then kill them and then make an argument for loss of control. Okay, you have to be a bit more than that. You have to do a little bit more than that. In addition to this, it does still say that you can use this evidence to try and establish the context for a qualifying trigger that could be valid, essentially. Finally, then, let's look at the case of the Crown versus Ashmelash from 2013. In this case, throughout a long process taking place over a long period of time, the defendant had been regularly taunted by the victim. And then one day, when the defendant was drunk, he decided that he had had enough and decided to stab the victim, which resulted in their death. Now, the question for the court was whether or not the voluntary consumption of alcohol was a factor which ought to be taken into consideration when thinking about Section 54(c) of the Coroners and Justice Act, i.e. the level of tolerance and self-restraint requirement. So the idea of essentially contextualizing the defendant's actions in relation to a reasonable person of similar characteristics, of similar tolerance and self-restraint, being put in those circumstances. It was held that the concept of loss of control, which was one which has to be approached without taking into consideration the voluntary intoxication of the defendant. Ultimately, we have a defense for crimes, which is that of intoxication, voluntary intoxication as well as involuntary intoxication, and that is very limited in terms of its ability to absolve an individual of criminal liability. Involuntary intoxication is far stronger, but it's far rarer, of course, and so therefore it cannot be taken into account when approaching issues relating to loss of control.